Welcome back to Geoff Randall Live. Now, the story of the man who left his two daughters a fortune while his wife was bequeathed only his second best bed may sound like a twist in one of William Shakespeare's comedic plays, but it is in fact a detail of the bard's own will. This record of Shakespeare's final wishes forms just part of the most comprehensive collection of probate records to be published online. The wills of some of the most famous names in history, dating back almost 5 centuries, were also released today by the website ancestry.co.uk. Pride and Prejudice author Jane Austen, who died in 1817, left the majority of her assets, around £800 or £60,000 in today's money, to her sister Cassandra, and £50 each to her brother and the family's former nanny. Almost 200 years earlier, the legendary sea captain Sir Francis Drake left 40 quid, or the equivalent of £150,000, to the poor of Plymouth. And the composer Handel was a little more self-obsessed. On his death in 1759, he left £600, that would be around £90,000 today, to build a monument to himself in Westminster Abbey. Well, joining me now is Andrew Kidd, a consultant at Clinton's law firm and a member of the Association of Contentious Trust and Probate Specialists. Nice to see you, Andrew. Thank you for coming in. Now, if a very rich man with a high profile, a bit like Shakespeare today, left his wife just his second best bed, my guess is that there would be a high chance of it being contested.
Well, quite possibly. I mean, one wonders where the best bed goes to, but
and
yeah,
to whom, yes.
and to whom quite.
How common is it for there to be a legal challenge to what appears to be a reputable will?
Well, it's becoming increasingly common for people to query and challenge documents of this nature, particularly if they haven't been provided for, and there may be an expectation. You know, people are generally more wealthy than they were historically, and families are more fragmented, and as a result of that, they're more willing to have a go. What
are the most common grounds for trying to repudiate a will?
When you say repudiate, you mean successfully challenge? Yeah. Well, there could be a whole number of grounds, from the document itself is not valid, it hasn't been signed in the right way in the presence of witnesses, or there's been an undue influence on the part of somebody, or more commonly, the will maker didn't have the requisite mental capacity to make the will at the time it was signed.
Yeah, that's the problem, isn't it? Because when we become very old and we rewrite a will, there is that obvious opportunity for the dissatisfied to say, well, he was old, he was a bit gaga, didn't know what he was doing, he should have given me the money.
Absolutely right. I mean, people are living longer, Alzheimer's is affecting the elderly more and more. So as a result of that, people are more willing to query those arrangements, and that's why it's absolutely crucial to seek the advice of an expert solicitor who's very well placed to make the assessment and give the appropriate advice.
The reason I like this story so much is that it tells us, or wills tell us, a lot about the private obsessions of public figures. Can you remember Leona Helmsley, the sort of rather ghastly New York socialite? She left $12 million to her dog, and it was called Trouble. Not surprisingly, that was contested.
Yes, I mean, not surprisingly, especially with an estate of that magnitude.
What about the story of, you remember the oil tycoon Howard Marshall? He was the old boy, I think he was 89, he married the stripper who was 27, and she thought she was in for a big pile of cash on his death. And he gave all the money to his son, and she challenged that, saying that the son had interfered. How common is that? Allegations against other members of the family?
Allegations are common. They have to be credible and sustained. I mean, we have testamentary freedom in England. You can leave a will, leaving your estate to whomever you wish. That's a fundamental freedom we have here. But where there is an expectation and there may be disappointed beneficiaries, then they're certainly willing to have a go.
But you can't write the spouse out of everything, can you? I mean, for instance, what about the house? You can't say, well...
Yes, you can. The spouse would have potentially be an applicant under the Inheritance Provision for Family and Dependents Act, which is an act of Parliament which empowers certain people to bring a claim to apply to court for reasonable provision, but you can certainly leave a will to whomever you wish.
I find this deeply troubling. I can sense Mrs. Randall scribbling away the will now, signing it off to the dog. What advice would you give people who
Well, I mean,
perhaps suspect that they're going to upset close family members with the will and they don't want it challenged?
Well, I think the advice is absolutely clear. They need to consult a specialist solicitor who is uniquely placed to advise on the whole range of complex issues which can be involved, and to make sure that the will is the most robust as it can be.
I went to Afghanistan last year, and as a result of that, or in preparation for that, I rewrote my own will, and I did it in the presence of a qualified solicitor. Would that make it watertight?
It would certainly make it more robust. So in that sense, yes, it would. It would make it as watertight as any will can be.
Right, and yet. Even a solicitor's goodwill and signature is not enough.
No will is beyond challenge. To consult the advice of a specialist solicitor is the best you can do, and that will get you as close to a will being watertight as it possibly can be.
For those who are thinking about bequeathing their wife a second best bed, you've been warned. Andrew, nice to see you. Thank you for coming in.
Likewise.